Good morning. My name is Adriana Brigatti. I am Director of Research Regulatory Affairs. It is a real honor for me to open the festivities and activities for Research Week with our responsible conduct of research performance. On behalf of CRI and the CTSICN and the organization committee, I welcome you to be the judge. RTR goes to the court. A special welcome to our colleagues who are joining us via WebEx and our friends from the GW Department of Theater and Dance. Thank you for joining us this morning. After this event at noon, we will have Dr. Melissa Parisi, Chief of the Intellectual and Development Disabilities Branch of the Eunice Kennedy Shriver National Institute, NICHD National Institute of Health, to present a lecture at noontime. You can reserve your seats. And then we will have our poster sessions from 1 to 3. So we will hope that this will be just the beginning of a fun day of learning and educational opportunities for all of you. Before we begin with the program, let's have some housekeeping issues. First, please keep your phones handy. You will have to use them today, but please put them on vibrate or mute, or lower the volume as much as possible so we don't disrupt the play. Today's event provides credit for responsible conduct of research interactive requirements for NIH grantees. If any of your grants include the D, F, K, T, or U awards, you need to fulfill 8 hours of interactive training in responsible conduct of research during the time of your grant. Today's presentation provides credit in order to fulfill that requirement. If you need credit, I would like for you to see the email of Kay Ayers. So she will, you can send it to her. And she can provide you with a certificate. You can also sign your name and indicate that you need the credit, and then we will issue a certificate. After the event, please don't forget to complete your evaluation forms. Those are really important for us, and that will be also an indication that you actually did attend the meeting. Okay, this is our 3rd year working with our playwright and director, Jody Cantor. And I'm going to invite Jody to stand so the public can recognize you. Where are you? Here's Jody. Jody has taken on the challenging task of taking ethical and regulatory issues, and in today's case, legal cases, to be represented and original scripts developed by her and presented in a way that we can debrief and learn from these experiences, which is, to me, an amazing work. And I'm very happy that she keeps working with us. And this is the 2nd year we have our wonderful students from the GW Department of Theater and Dance, and 4 of them are graduating in a few weeks. So I'm saying, in a way, a little bit of goodbye with a broken heart, but I want to wish them the best in your careers. Thank you for joining us and helping us. So here is Kate's address. Please write it down. And if you need a certificate, please let us know. We will be happy to send it to you. Okay, today's program occurred in a courtroom. And you all have been summoned and called to be jurors. The cases you are about to hear are all controversies occur in the context of research. These cases challenge the traditional notion that science is independent or different from other areas of the human endeavor. Scientific research is based on the overall structure of reward and punishment. The reward of a scientist is the publication, the credit. That is recognition of the work. And that implies that the scientific community trusts and has to conform to the honesty of the individuals creating that knowledge. To avoid the punishment, the non-recognition, the lack of credit, there is a strong incentive or an opportunity to be untrustful or to deviate from the standard rules. It is understood that the community issues in scientific research are managed by the standards of peer review. However, we know that in practice it's very challenging to achieve review of truth or rejections of the truth. So we need to trust. We need to trust our colleagues. Independently from what our colleagues develop as a truth, we need to realize that scientific research is founded by public funds, that the community and the society as a whole expects and wants to believe that progress is based on that knowledge being developed. So the consequences of scientific research go beyond the area of our area of development, go beyond the area of our use of the funds. It really implies the whole society. Modern research does not operate in a framework of specialties. It operates in a framework of big science, the organization of large number of scientists bringing different bodies of expertise to a common research project. Research has transformed from a small-scale university to institutionalized and even international activities with multi-task projects and major economic impact for national and international consequences. As we see today, the behavior and decisions of each member of a team have an impact not only for the outcome of experiments, but it has a social impact. That's why at certain points, the courts and the regulatory agencies get involved. The impact of research extends beyond the laboratory, immediate applications, or published papers. Today's program consists of 3 short plays inspired in real cases, dealing with scientific research controversies that were decided by the courts or administrative federal agencies. These cases showcase the largest social responsibility in the practice of research. Each play is a short court case in which you are invited to be the jury and decide the outcome of the claim. Although we will tell you which case inspired this play, and we will compare the results of your decisions with the actual court decisions, we do not embrace or reject any of the court decisions. We are presenting this just so you can learn and be informed how these issues are being seen by the courts and administrative agencies. So the views and legal opinions presented in this session are intended for educational purposes only. They do not constitute legal advice or the official opinion or position of Children's National or George Washington University. The characters are not intended to be true representations of the characters in the real cases either, but the individuals involved or any of the actual persons. Statements or opinions are those of the individual participants, and it doesn't represent an official position of Children's National. These sessions will be audio recorded and may be published in media, including print, audio, video formats. Okay, so in all court cases, the jury has to go to some jury instructions. And here is your jury instructions. So the way you will be able to deliberate and vote is by using your cellular phone. The website that you need to log into is in the program, but it's also here in this slide. So please go ahead and use your smartphone or tablet and go to http://ubthejudge.participool.com. You will see a screen that has several color-coded options. Your responses will be A, B, C, or D, and results will be displayed on the screen after everyone has voted. So let's do a test. Okay, so let's do a sample participle question. Which one of the following is your favorite bear? We have Yogi Bear, A. Option B, Clark the Chicago Club Bear, Dr. Bear, and Smokey Bear. Please cast your vote. $49, $452, 4, 55. We will give you 10 more seconds. We are at 61 votes, 62. Okay, now? 3. Okay, 5 final seconds. We are at 70 votes now. Okay. Let's move forward. Okay. Let's see. And the winner is Dr. Bear. Okay. So now that the jury knows how to perform their duties, we are ready to hear the first case. Ladies and gentlemen, this court is in session. The Honorable Judge Cleary presiding. Please all rise.
Please be seated. We will now hear an appeal in the case of Dr. Important versus the University of Boise. This is a custody case, and because in the opinion of the court, the ward is old enough to have a voice in this appeal, she has been invited to make a brief opening statement. We will now hear that statement.
Thank you, Your Honor. My name is Charmaine, and I am a tissue sample. Ladies and gentlemen, 3 months ago, I belonged to that woman sitting there in the front row. Hi, Mom. Then, Mom decided to put me into the expert hands of Dr. Important. Dr. Important, as you know, is one of the country's leading experts in Meniere's disease. She has been doing experiments on tissues like me for the last 30 years. Mom trusted her. She knew the doctor would keep me safe and that she'd use me in experiments she designed in order to help some very sick people. She knew it was a better life than she could have given me, a more meaningful life. When Dr. I accepted her new job at Fancy University, she packed me up to take with her, but Boss Yu wouldn't let me go. He sued Dr. I, and the court gave him legal custody of me and all of the doctor's samples. And now I'm facing a life in the hands of a guardian I don't know and frankly don't trust. I have no idea what kind of research I'm going to be used for and by whom. For all I know, Boss Yu could lock me up in a freezer for the rest of my life. I hope that you will be able to help me go back to where I belong, where I can make a difference.
Oh, my goodness, that was so moving. Thank you, child. Thank you very much. The court will do its utmost to bring you justice. Why don't you come up and sit here by me, my dear, so that everyone can see you? I always feel that in these sorts of cases...
Your Honor, please, may we continue with the appeal?
I'm sorry, I'm listening.
Very well, Your Honor, very well. The defense will call as its first witness to the stand. Please. Ma'am, will you please state your name for the record?
I'd be happy to. It's Samantha.
Your full name, please.
Samantha, human subject. Human was my maiden name.
Was it your understanding, Ms. Subject, that in making a gift of your tissue to Bossy Yu, you had agreed to the use of your tissue first and foremost by Dr. Important for use in her research around Meniere's disease?
Absolutely. She told me it was a gift, you know, like that perfect tie your dad always wanted, and you find it on Amazon. You give it to him for his birthday. That kind of gift. You don't give that kind of gift to an institution.
Then the fact that it was Dr. Important conducting the study, that was important to you.
Of course. I was a patient of Dr. Important. I had struggled with Meniere's disease since my early 20s. Until I met Dr. I, no one knew how to do anything to help me. Dr. I is the one who was able to restore some normalcy to my life. I was hoping my tissue could help her find a cure.
And Ms. Subject, was it your understanding that you waived all rights over this part of your body once it was removed from said body?
Absolutely not. In fact, I was told that I could change my mind and even ask for the sample to be destroyed anytime I wanted.
Mom!
Oh, Really? I would never in a million years.
Thank you. Thank you, Ms. Subject. No further questions, Your Honor.
Ms. Subject, did you sign a document agreeing to participate in Dr. Important's study?
Yes, I did.
Is this your signature on the page 118?
Yes, it is.
Your Honor, I would like to note in the record that the consent document is on university letterhead. I'd like to read the document to the jury.
Proceed.
I, Samantha H. Subject, agree that my tissue specimens can be stored and used for future research to help investigators better understand, prevent, diagnose, and treat near. If I change my mind at a later time, I may request my tissue specimens be destroyed. My request must be made in writing to Dr. Important at the University of Fort. Thank you, Your Honor. No further questions.
Proceed.
The prosecution would like to call Boise University to the stand.
Right. I'll come to the stand when I'm getting ready to come to the stand.
Are you ready to come to the stand?
Yeah, I'm ready.
Thank you. All right, then.
Tell us to turn on your...
Okay.
Please tell the court how long you've been an accredited university.
Since 1918.
Is that right? You're in remarkably good shape.
Well, I try to work out a couple times a week. I limit the carbs.
In your experience, is it usual for the university to hold on to the specimen of a departing faculty member?
Happens all the time. How do we know that the place the faculty member goes is going to have the same standards for the responsible conduct of research that we do? We have a responsibility to protect innocent young samples like her.
Oh, listen to him, Your Honor. That man is clearly a patronizing sector.
You saying she's not so innocent, huh, lady? You don't want her to be protected? I know better.
Order, order.
And what if the subject tells that they want their samples to stay with the researcher to whom they originally entrusted them?
The research participants clearly intended at the time they provided their tissues to make a gift to BU. They agreed to participate in research taking place at BU and signed an informed consent document that bore our well-known logo.
But it was Dr. Important who designed all the studies in which samples were obtained. It was Dr. Important who provided all the expertise for the use and development of the tissue in the research.
Look, Dr. Important or anyone else who is part of a research institution has to understand that she is our employee. We paid her salary, benefits, and liability insurance premiums. Dr. Important practiced medicine and conducted research solely as a BU employee. We provided all the infrastructure she needed. Virtually all the scientific research in which she advanced her projects was done in a collaborative way and was a team effort involving substantial work by many clinicians also employed by BU. And the repository has a monetary value, too. We could license the repository to a pharmaceutical company or another institution. We got skin in the game, so to speak.
Is there any reason to think we are talking about a particularly valuable set of samples here?
Are you kidding me? Dr. Important is one of 4 researchers working in this area nationally, and her repository is the largest of the 4.
And what if the professor argues that it's her unique contribution to science that earned her the trust and support of the sponsor, Generate Pharmaceuticals?
As long as she was conducting research in our facility, BU bore the legal, regulatory, and compliance responsibility and risk for the research. And even if you grant that she didn't need us in theory, that consent document clearly stated that the tissue was a gift to us.
To me. It was a gift to me.
It was a gift to us.
Order, order.
What I was trying to say, Your Honor, is that we can use those specimens to do valuable research in all kinds of other areas. And I'll tell you another thing. Dr. I signed papers waiving her intellectual property rights on the research. You should get your grubby little hands on those documents.
I think we've heard enough.
Thank you very much, Boise University. You may step down.
Hey, don't you tell me when to step down. I'll step down when I'm good and ready. Okay, I'm ready.
Your Honor, the prosecution would like to call as of our final witness, Dr. Important herself. Can you explain to the court, Dr. Important, the basic aim of your research?
I am a leading international expert in the diagnosis of Meniere's disease and other progressive diseases that lead to hearing loss.
Can you describe the state of your research when you left the Boise University?
As has already been said, I had received major sponsorship from Generous Pharmaceuticals to extend my research.
Dr. Important, is it true that you own the stock at Generous Pharmaceuticals?
Yes, that's true. A little bit of stock.
I wouldn't call 10,000 shares a little bit of stock.
Okay.
Dr. Important, why is it so critical to you that you take the tissue with you to your new institution? Couldn't you simply collect more tissue?
I built this repository. It would take years to rebuild it, but for me, this is more than about a timeline. A whole career's worth of former patients entrusted these tissues to me. I have a relationship with them.
Get your hands off of her.
Objection! Objection!
Sustained. We need to settle this appeal here and now. And for some of us, it's been a very emotional day. So let's all take 3 deep breaths. Come on, you too. 1, 2, 3. Now, here are the questions. The jury will now deliberate. You be the judge.
Okay, so this play was inspired on the real case of Washington University versus Catalona. Dr. Catalona collected biological samples and associated clinical data for about 20 years with the consent of the research participants. He did that during his tenure at Washington University with the support of all his colleagues. When Dr. Catalona accepted a position at Northwestern University in 2003, he attempted to transfer the biological samples he had collected for 20 years. He obtained the consent form from 6,000 donors subject to transfer the samples to his new institution. Washington University sued Dr. Catalona to establish ownership of the biological samples. The case was first decided by the U.S. District Court for the Eastern District of Missouri in March of 2006. The lower court decision was upheld by the U.S. Court of the Eighth Circuit in June 20, 2007. The Eighth Circuit Court decision was appealed to the U.S. Supreme Court, and the U.S. Supreme Court denied certiorari without comment on 2008. So the case, this is one of the most recent cases about tissue ownership, so this is the most current case we have. So here are the questions for you, the jury, and you can deliberate with your colleagues for a few minutes before you cast your vote.
So as before, you want to use your cell phone to go to the site, youbethejudge.participle.com. And our first question is Charmaine, our tissue sample, a gift? A, yes, because Ms. Subject gave her sample to Dr. Important without any payment in exchange. B, no, because Ms. Subject can always request the destruction of her sample, so she has effectively retained ownership. C, yes, because Ms. Subject signed an informed consent form agreeing that her sample could be used for future research. Or D, A and C. So please cast your vote. Those of you who are joining us by WebEx should also be able to vote, so please do so. Okay, any last votes?
Wow, 84, 85. Maybe. Okay, I think this is it.
Okay, we're going to close the polling. And let's see what you said. So a near tie between B, no, Ms. Subject can always request destruction of her sample, so she's effectively retained ownership, and D, A, and C. So we've got quite a split.
Okay, so let's see. I would like to hear from the jury. May I have anyone who voted for option B tell me why? Charmaine is not a gift because the subject can always request the destruction of the sample. Can I have anybody who voted for B tell me why? Yes.
I would because I feel that that's what you as
So actually, in the Catalona case, the donors were part of the trial, and they argued that their ability to request the destruction of the sample was proof of their ownership of the sample. Against that argument, the university said that return of samples to study participants is forbidden by state law because of biosafety concerns. So you can order the destruction, but you can never get the sample back to you. So it's a very interesting situation with donations. What about anyone who voted for D, A, and C? So yes, it's a gift because the subject gave the sample to Dr. Important without payment, and because the subject signed an informed consent agreeing that her sample could be used for future research. Anybody who voted for D? Anybody? It's a very shy jury. Okay, so let's see how your decision compares with the Catalona court. The Catalona court decided that actually tissues and samples given in the context of research are a gift because all the elements of a gift are included when people provide the samples via a consent form. They have the donative intent, they deliver the samples, and the institution accepts the samples. Participants in Dr. Catalona intended to donate their tissue and blood samples to the university for medical research, and the research participants knew from the informed consent they signed that the research would not benefit them, but they hoped it would benefit future generations. Okay, the jury now has to decide the second question.
In this case, what kind of property are tissue samples? A, tangible, material, mobile property like tables and chairs. B, intellectual property. C, common good, because knowledge is a common good. Or D, A and B. Please go to the site and cast your votes.
Okay. 90. Okay, we're about to close. Okay. 95. Okay. All right. Okay. We have 50% for option D, which says that tissues are tangible materials and intellectual property at the same time. And I have to say that the Catalona court agreed with the majority of this jury, as the court based its decision on the Washington University intellectual property policy, and it stated that all intellectual property, including tangible samples, is governed by the policy. And the reason why the court used the intellectual property policy is because they thought that the tissues without the expertise were just like another discarded sample. However, when you have a repository in an academic institution, it's always attached to intellectual property. So in the Catalona decision, tissues are both. And as an employee of Washington University, Dr. Catalona was subject to institutional policy when he collected the samples. And the final decision for this court, who owns the tissue sample? A, Ms. Subject, because it came from her body and she can decide the future use of the sample or request that it be destroyed. Boise University, it employed Dr. Important and provided resources and infrastructure for her study. It belongs to Dr. Important because she kept the samples in her own repository and is the person with the specialized knowledge. Or D, the scientific community because knowledge is a common good. Okay, please go and cast your vote. Okay, and we have 65% deciding that Boise University owns the samples because it employed Dr. Important and provided resources and infrastructure for her study. And actually, the Catalona court would agree with this jury, as the Catalona court decided that the samples were gifts given to Washington University and not to Dr. Catalona as the individual. The consent form bore the logo of the Washington University Medical School and was approved by the University IRB. Not all samples came from Dr. Catalona patients. Many of the samples were contributed by other collaborators. And I think being part of a collaboration, that was a big part of the reason of the decision. All the studies were collaborative efforts. Washington University provided all the infrastructure and were the legal and compliance responsibility. And the material transfer agreement that he signed when he was employed at the university, in which numerous transfers happened with his colleagues around the country, were also an acknowledgement that those samples were part of the university. So thank you for your vote. This case is now decided. Now we will move to the second case that we will hear this morning. The Honorable Judge Cleary is still presiding. All right, please.
Yep. Please be seated. Order, order. The court will now hear the case of Mr. Lionel Longtail versus Dr. Jennifer Johnson. Mr. Longtail alleges that Dr. Johnson, a staff scientist at Wazoo Hospital, provided inadequate and deficient research monitoring, deficient research monitoring in her supervision of a graduate student, Ms. Alexander Wong, during the conduct of the Iacocca-approved study, The Effect of Cannabis Ingestion on Adolescent Mice. The plaintiff requests action by this court to prevent any recurrence of such negligent mentoring behavior.
Thank you, Your Honor. The prosecution would like to begin by calling Mr. Lionel Longtail to the stand. Mr. Lionel Longtail to the stand, please. Mr. Longtail.
Oh, me, sure, sorry. Here I come.
Right here, Mr. Longtail. Take your time, sir. All set, Mr. Longtail? Mr. Longtail, during the experiment in question, is it true that you never saw Dr. Johnson at the lab?
That's right. I never saw her, even though she was supposed to be making sure that my welfare was protected. 1 Mississippi, 2 Mississippi.
And everything all right, sir, Mr. Longtail?
Well, oh, yeah, sorry, nervous habit.
Mr. Longtail, are you anxious by nature?
Not really. I mean, you know, there are the run-of-the-mill stressors of life, bills to pay, traps to avoid. Not to mention those horrid cat videos that I see the lab staff watching all the time on their computers. They give me the willies, 1 Mississippi, 2.
But sir, nothing unusual. No panic attacks or violent hallucinations?
No, nothing like that.
And before this experiment, had you ever smoked marijuana, sir?
Well, once a long time ago, when I was in college, but I didn't inhale.
I see. Mr. Longtail, can you tell us in your own words how you felt during the weeks of the experiment?
Do you mind if I look at my log?
It really isn't necessary. Just tell us as you remember it.
I'd feel more comfortable looking at my log.
All right then, sir. Please, look at your log.
Day 1. I feel strangely mellow. A hand pops in regularly to feed me Swiss cheese. It is the most amazing Swiss cheese I have ever tasted. Day 2. I continue to feel peaceful. The cheese here is still outstanding. Strange, though. I eat my fill at every meal, but feel hungry again in no time.
The defendant will be seated. Continue, Mr. Longtail.
Day 3. I'm not feeling well today. I have a headache and my heart is racing. My roommate, Mickey, makes me nervous. I hope I will be able to sleep. Day 4. Mickey is definitely out to get me. I didn't stop scurrying all day. Had to stay on my toes while he was asleep. I searched the cage for firearms. Day 5. A vicious-looking cat has stepped out from one of the computer screens and is stalking his way toward me. I'm yelling as loud as I can, but none of the humans seem to hear me. Maybe if I threw myself at the side of the cage, they would notice.
Thank you. Thank you. Thank you, Mr. Longtail. That's enough. And what did Dr. Johnson do when this was going on?
Like I told you, I never saw her. Just Alexandra, the research fellow.
I have no further questions, Your Honor.
Mr. Longtail, did Alexander Huang feed you well during the week of experiment?
Oh, the food, yes. The food was outstanding. I took notes after every meal. Day 1,
That's
breakfast.
necessary, Mr. Longtail.
All right.
Was the light and social interaction to your satisfaction?
The light was just as I like it. Ambient, subtle, none of those harsh fluorescents. And Mickey and I had been roommates before. He's an excellent conversationalist.
So, in other words, you were well cared for by Miss Huang.
Well, that part wasn't so bad, that's true.
Did she keep a close watch over you during the week of the experiment?
Yeah, she kept me company, even sang to me a little. Nice mezzo-soprano voice. But when I was being stalked by the YouTube cat, she didn't lift a finger to help me. I was scared out of my wits. 1 Mississippi, 2 Mississippi.
Thank you, Your Honor. I have no further questions.
You may step down, sir.
Let me give you a
No, I'm fine. Thank you.
Your Honor, the prosecution would next like to call Dr. Johnson herself to the stand.
Proceed.
Dr. Johnson, can you please summarize for the court the results of your experiment? Let me assist you, Dr. Johnson.
The data clearly showed, as we expected, that the mice experienced a marked increase in anxiety and anxious behavior after repeatedly ingesting cannabis.
And you certainly reviewed the data collection forms yourself?
Oh, not every form, no. I just looked at the aggregated data.
I see, but naturally, you had reviewed the research protocol with her in some detail, am I correct?
She's an excellent student. Alexandra knew it as well as I did. Also, it was completely in her interest to do this well. It was part of her dissertation.
I see, but you reviewed the standards, certainly, for capturing data?
Again, Ms. Huang is an excellent researcher, smart. They usually are the research fellows, hard workers, good scientists.
I see. Were any of the results you obtained unexpected?
Yes, actually, our data suggested that the ones that were pregnant passed their cannabis-induced anxiety onto their babies.
I see. You conducted the experiment with pregnant mice?
Well, they weren't pregnant when they started the study. We examined them prior to selection, of course, you know. It's just like human teenagers. We really have no idea what they're doing before they come home at night. So you give them your blessing and hope for the best.
And has no one done a study of the effects of cannabis on mice before?
They have, but they've only administered a single dose of the drug. We administered it daily for 5 days.
I see. You really wanted to get those mice high as kites, huh?
Objection!
Sustained.
Just one more question, Dr. Johnson. What does a mouse in acute distress look like?
What does it look like?
Yes.
Well, I mean, there are different responses in different species, but generally, the mouse is frenetic in its movements, squeals incessantly, emits certain unusual odors.
Funny. That sounds a lot like how Mr. Longtail described his behavior. Except for the odors, were you aware of any unusual odors?
Well, no, but I wasn't physically there.
What do you mean you weren't physically there?
I was at home. I had the stomach flu. It was pretty disgusting, if you know what I mean. And of course, I did not want to expose any of my staff, so I had to stay home.
I see. And who ran the experiment in your place?
My research fellow, Alexandra Huang.
She ran the experiment alone?
Yes, but I served as a second observer. I watched when I wasn't running to the bathroom. I was available on Skype for any questions.
You were on Skype all day, each day of the entire experiment?
Sure.
You weren't distracted by anything? Email, the phone, Facebook?
Well, I might have checked my email once or twice, and sometimes when I went to the bathroom, it timed out and I had to reconnect. But if a mouse is in acute distress, that's not going to go away while I'm refreshing the screen, you know.
I see. And Dr. Johnson, how clearly were you able to see the mice on your computer screen?
I have a very large screen, and the lab has an excellent camera. I was able to see just fine.
And then according to this very close observation, did Ms. Huang carry out the research properly?
She did. We got excellent data. It was superb. The quality of the data was really superb. I really don't see what the problem is here, just because that little pipsqueak,
Sustained.
that little rodent who has no scientific training whatsoever is claiming that he was in acute distress.
And had any of the animals gone into acute distress, doctor? You would have been able to observe it yourself?
That's right. Acute distress is not subtle. And look, I'm as sorry as anyone that the little guy was uncomfortable for a couple of days, but clinically he was perfectly safe.
Thank you, Dr. Johnson. No further questions, Your Honor.
Counselor, proceed.
Your Honor, the defense would like to call Ms. Alexandra Huang to the stand. Thank you. I will take this. Thank you, Ms. Huang. Ms. Huang, how long have you worked at Dr. Johnson's lab?
18 months.
And can you describe to the court the nature of your relationship with Dr. Jones?
Jennifer has been a wonderful mentor. She's supported my entire learning process. She's introduced me to key leadership. She's listed me as a co-author on articles where we've done work together. I owe her so much.
Has Dr. Johnson's behavior ever concerned you from the ethical point of view?
Oh, not at all. She gives me a lot of autonomy. Of course, sometimes that can be stressful, but ultimately it motivates me to do things right.
You understand, don't you, Ms. Huang, that the charges brought against her by Mr. Longtail are very serious?
I do, and I just want to say I take complete responsibility for how the experiment was conducted. I didn't have any intent to harm Mr. Longtail. I was just invested in completing the experiment.
Thank you, Ms. Huang. No further questions, Your Honor.
Your Honor, a few questions, if I may.
Yes, please.
Ms. Huang, is that your lab notebook?
Yes, it's pretty old and beat up now, but it looked much better when I started.
Would you hold the notebook up such that the entire jury can see it, please? I noticed that there are a large number of Post-it notes in this notebook. Am I right?
Yeah, I color code the data as I collect it.
And do the Post-it notes ever fall out of your notebook?
Oh, no, I'm very careful. And I don't eat or drink anything but water when I'm working either.
Do you consider this proper record keeping?
I've been using this technique since I began doing research in my first summer job. Dr. Johnson never asked me to change the practice. In our lab, there's a lot of trust. Each investigator uses the approach to record keeping that works best for her.
I see. And Ms. Huang, during your extended observation, did you at any time notice any unusual behavior as demonstrated by Mr. Longtail?
Yes, sir. Late in day number 3 of the experiment, I noticed that Mr. Longtail was agitated.
Agitated?
Upset. He was upset.
How did you know that the mouse was upset?
His movements were frantic.
I see. And what did the research protocol call for you to do in response to such frantic behavior?
I was supposed to consult with the PI and then, if necessary, with a veterinarian.
And did you discuss the behavior with Dr. Johnson?
I did. She was observing by Skype, as she said, but she said that since I was the one in the lab, she trusted me to make the call. It wasn't until the final day of the experiment when I saw Mr. Longtail frantically trying to get out of the cage, I knew that was one of the signs of acute distress.
I see. And at that point, did you consult a veterinarian?
I didn't at that point. The experiment was practically over.
Did the research protocol identify a point in the experiment at which the reporting rules ceased to apply?
No, sir.
I see. Thank you, Ms. Huang. No further questions, Your Honor.
No further questions, Your Honor.
Does anyone else have anything to say?
Just one thing, Your Honor. I'd like to say that I arranged for live note-taking system, and if Ms. Huang would like any further mentorship in standards of data collection, I'd be happy to spend some time with her.
That's very generous of you, Mr. Longtail. I will connect the two of you by email in case you want to meet for coffee.
Well, I can drink coffee, even if we take in the morning, I'll be sure to be for the rest of the day.
I understand. All right, ladies and gentlemen, and mice, the jury will now deliberate. You be the judge.
So this very enlightening case is actually based on this publication from 2008, which basically was a review of the Office of Research Integrity cases from 1990 to 2004 that involved trainee misconduct. 158 of the cases of trainee misconduct were identified, and 30% involved trainees working under the supervision of a mentor. And 79% of the cases involved joint research with faculty. So we have some questions for the jury. Question number 1, how would you characterize Dr. Johnson as a mentor?
Are we all good with our iPhones now? So was she good, deficient, or as good as it gets? Okay. I think when you look at this question, I would say it's which is the most correct. You possibly could think there's two more people to vote, unless they've left the room. There we go, 101. Okay. Excellent. That's excellent. Well, I don't have anything to say. Everyone really recognised that she was indeed deficient. And so certainly in 62% of these misconduct cases adjudicated by the Office of Research Integrity, the mentors failed to set standards and failed to properly supervise their trainees. In particular, trainees did not receive proper training and best practices for keeping laboratory notebooks, collecting and maintaining data, and other laboratory procedures, as you saw very elegantly highlighted by the skit. So since we did so well with that question, this is the next question. Again, which answer is most correct? Who is responsible for the quality and integrity of the research? Is it Dr. Johnson? Is it Dr. Johnson and Ms. Wong? Is it all the manuscript authors? Is it no one should be reviewing the data? We're all honest and self-correcting people in research. One more person, excellent. Okay, so, oh, wow, we're a bit split here. Is anyone brave enough to tell me why they chose what they did? People from my group. Who put A? All up to me.
What a diabolical laugh there, Doc.
All falls on me. Oh, you put that, Kirsten. Okay. All right. Great. Yes.
If it's possible, and
it could.
When you have a large program, it's really an honest expectation that can eventually that's correct.
So
how do you go about that in your program?
Exactly. Well, so yeah, before I did this talk, I actually pulled everyone together, and I think it is important. I think as mentors to make sure we do see the raw data. It's very easy when we meet once a week to just see aggregate data, but we now, have a process in place that raw data is analyzed by the person ultimately responsible. I do think that this question has multiple correct answers, which I think reflects the split here. I personally went with C. I think if you're going to have your name on a manuscript, you need to be aware that you're responsible for
taking ownership of that data as well. And I think the people most vulnerable to that are often junior people who want to have their names put on papers and to build up their CV. And I think, you know, you do need to be careful about just having your name put on a paper for the sake of it. So, and these days journals are getting more specific about making sure you write down the role of each individual author on that manuscript. But, you know, at the same time, I agree with Kirsten that at the end of the day, the person who is ultimately responsible in the lab, who's usually the head of the lab, should take prime responsibility for.
Dr. Bullard, but what about the case of multi-center?
How come I'm on the chopping block of it?
Multi-center clinical research where team science prevails and different centers.
So those sorts of research, they're audited by independent auditors, and I think it's a different situation. If you like, in a lab, you know, I guess, you know, auditing practices should come from the top. I agree with that. But yes, in multi-center team science setting, there's in good practice would be independent auditors of the integrity of the data. Okay, well, that's good. So the mentor's role in reviewing the data. So in the majority of the OI trainee misconduct cases, 73%, the mentors had not reviewed the raw data generated by the trainees. And best practices dictate that research results should be recorded in a form that allows continuous access to analysis and review. And so whether that is you have a shared drive in your lab where your mentor or mentors can access all your raw data, that's one way around there, or presenting on a regular basis. All research data must be made available to the supervisor as well as your collaborators, even if they're not in your institution, for immediate review. Obviously, HIPAA laws apply here, so if you're using human samples, the data needs to be de-identified or coded, depending on what your IRB approval states. And data management, including the decision to publish, is actually ultimately the responsibility of the PI, but obviously anyone on a paper needs to have access to the data ultimately. Any questions at this point? If not, the final determination of the jury for Dr. Longtail, is it Dr. Longtail? Are you a doctor, sir? Is he still here? Dr. Longtail's claim is should Dr. Johnson be allowed to continue performing as a mentor to trainees? Yes, yes, no, no. Or yes and no, I guess. Okay. Oh, split. That's interesting. So actually, yeah, B and C were my correct answers too. Anyone who wants to say why they chose B? Yes, if she commits to being a better mentor. How's she going to commit to that? Anyone who wants to speak up for the answers to C? Needs to get training on proper mentorship? Yes, sir.
I could suggest should, because that's a hard call to make. I know that's subjective. It's hard to tell what a mouse is stressed, which is why there's such a, I guess, place to end experiment include their judgment.
I guess I'm worried that she doesn't really understand the fundamentals of what's required to be a mentor. So in order for her to commit and write her own SOP, she probably does need training. She does need more training. That's my personal feeling. The judge is nodding, by the way, so that's got to be good. So ORI best practices dictate that mentors should instruct trainees how to conduct research responsibly, provide proper supervision and review of trainees, critique and support trainees' research, promote trainees' career in research, socialize trainees into their profession, assist trainees to establish a network of professional collegial relationships, and steer trainees' research agenda or training in a productive direction. So based on the paper by Rice et al., they concluded that the most important activities that mentors should perform with their trainees are, 1, review source data, 2, teach specific research standards, and 3, minimize stressful work situations. So I guess all of us who are mentors, we should learn from this and consider how our own lab operates and how we review our source data and teach good research practices in our lab, as well as making the lab as fun and least stressful as possible. And so with that, I rest the case.
Nicely done.
The court will now hear the third and last case for this morning. This is the claim related to the Music Man. The Honorable Judge Cleary presiding. All right.
Please be seated. This next case involves a few celebrities, so I'll admonish the court right now to maintain strict order, or I'll have the bailiff escort you right out into the street. The question before the jury is whether the defendant is guilty of the fabrication and or falsification of data that is unfortunately already widely disseminated. Yes, what is it?
Some musical accompaniment, if that's okay.
What? Oh, yes, I see. That would help the courtroom keep calm.
Got one more line there.
I thought she was supposed to play first. Okay. Okay. Beautiful, beautiful. Thank you, little girl. All right, now, let's get to it. Miss Prosecutor, you may proceed.
Can we?
Beautiful, beautiful. Please, you may proceed.
We would like to call as our witness 3 of Professor Hill's most outstanding graduate students, Your Honor. Mr. David Crosby, Mr. Stephen Stills, and Mr. Graham Nash. Unfortunately, Your Honor, Mr. Neil Young was not available.
Oh, I'm very excited. I'm so happy to meet you. I'm a big fan of yours, gentlemen. A very big fan. Oh, little girl?
Yes, sir.
Would you stop playing for a moment? I want to ask these men if they will sing for us. Would you be so kind, gentlemen?
Maybe after the verdict.
Of course, of course. Let's get to it, Counselor.
Very well, Your Honor. Mr. Crosby? Mr. Stills? Mr. Nash?
I'm Nash.
Oh, forgive me. Now, would you please tell the court what you observed in Professor Hill's lab?
A lot of people think of us as just a band, but when we're not on tour, we're a postdoc. We were supporting Professor Hill in some experiments he was conducting
at River City University regarding musical perception in infants.
Yes?
The standard protocol for these types of experiments is to have two independent researchers observe tapes of the subjects. I was hard at work on another project, so that left Stills and Nash as observers, along with Professor Hill.
So we thought, great, we'll have 3 separate observers. And then we all watched the tapes and coded the data.
Afterwards, we compared notes, and the thing was that the stuff the 2 of us recorded was in perfect harmony.
Our data showed a negative result. Very few of the babies in the research pool turned their heads towards the speakers in response to a new sound pattern.
But that's not what Professor Hill saw, or said he saw.
Well, it bothered us, of course. So we suggested that we bring in another independent observer to help settle the discrepancy. We knew our colleague, Neil Young, had just finished a big project, so we suggested him.
But Professor Hill said he didn't want to spend any more time on it. He said he was busy teaching, running a lab, and trying to meet a publication deadline. He said that was the end of it. That's when we knew something was very wrong. So we talked about it. How are postdocs supposed to report a superstar researcher? What if we're wrong? Maybe we just didn't understand. We felt helpless. Helpless.
And then things got really bad.
He published his research, just his research, without our conflicting observations. We knew we had to do something.
I had a mentor when I was a grad student, and I went to see her. I laid it out hypothetically, and she was straight with me. Told me it would be tough, but we needed to do the right thing.
So we went to the university's research integrity officer, and we told her. And that was when the weight started to lift from our shoulders.
Yeah. The Rio initiated an inquiry and figured out that this was not an isolated case. She found other cases published by Professor Hill where his hypothesis may not have been supported. In fact, she thinks this may have been going on for as long as 7 years.
7 years? But that would have consequences for the entire scientific community.
Exactly, Your Honor.
This is more serious than I realized. All right, the defense may call its first witness, please.
Thank you, Your Honor. The defense calls Professor Harold Hill, a.k.a. the Music Man, to the stand. Professor Hill, please.
Certainly and gladly, my boy.
Please. Professor Hill, would you please describe the parameters of your experiment?
As most of you know, I've been doing research on infants' musical memories for decades now. Why do some children speak, read, and write so much earlier than others? The answer, my friends, is music. Music with a capital M, and that rhymes with M, and that stands for memory. If a child can recognize a musical pattern, she can learn to talk. That's right, ladies and gentlemen, your infants can learn to talk perhaps as early as 6 months of age.
And what is the relationship between language and musical memory?
I established a musical pattern, you see, and then I changed it around. Wanted to see if the babies in the room turned their heads to the speaker where the sound was coming from. If they did, it was clear that they noticed that the pattern had changed.
Fascinating. And how did you set the experiment in this case?
Well, I established the musical pattern. And then I changed it around. I wanted to see if the babies in the room turned their heads to the speaker where the sound was coming from. If they did, it was clear that they noticed the pattern had changed.
And what did your first experiment related to cognitive development?
Oh, no, my boy, not by a mile, not by a country mile.
Is it true, in fact, that your research has been widely published and that you have occupied the distinguished chair at River City University for the last 25 years?
True, true, I don't mind saying so. Very true indeed.
And forgive me for asking, Professor Hill, but have you ever been accused of falsifying data before?
Nope, never have, never have. Integrity is my middle name. Well, actually, it's Adam with a capital A, and that rhymes with J, and that stands for.
Thank you, Professor Hill. No further questions, Your Honor.
The prosecution may cross-examine the witness.
Thank you, Your Honor. Professor Hill, is it true, sir, that much of the data showed that the infant's reacting to the sound stimuli much differently than you reported?
Well, that is true if you count the observations of my research fellow.
And is it true that you omitted that data from your analysis in order to support the results upon which you have built your previously stellar reputation?
True indeed. But you see, my boy, my data was more reliable. Why, I have more experience in capturing data than these three gentlemen put together.
But the failure to report large amounts of data can be considered fabrication or falsification of data, a violation of the basic national guidelines for the responsible conduct of research. Would you agree by that definition, sir? You were conducting your research irresponsibly?
Well, I may not have been correct in my coding all the time, but then who is?
Professor Hill, is it also true that you republished the results of this study in not one, not two, but three highly respected national medical journals?
Yes, sir. Results or no results, gotta figure out a way. I meet my deadline every time, and I'm mighty proud of those three articles. Mighty proud indeed.
But isn't it also true, Dr. Hill, that to date, two of these three journals have learned that you've been accused of falsifying data and have asked you to retract said findings?
Now, I know all you folks are the right kind of people, and I'm going to be perfectly frank. Nobody in River City reads these highly respected medical journals. No one, I say. So retraction or no retraction, who's going to be any the wiser?
That's hardly the point. Wouldn't you agree, Professor Hill? The point is that the integrity of the research record must be maintained for the benefit of the entire scientific community. Professor? Might have different drafts of the script. The people in River City may not be reading these journals, but serious scientists all over the world.
But as I said before, this doesn't affect anyone in River City. Sorry about that.
We are quite literally back on the same page. People in River City may not be reading these journals, sir, but serious scientists all over the world are. And they do read them, and they build their own research programs on what they read. Furthermore, your research is supported by grants and by public funds. So it's wrong to misuse those funds, sir. Nonetheless, if no one's going to read it, then why refuse to retract the research?
Because it's not my style, sir. No, sir. The good people of this community don't go in for any old printed retraction. We'll set it to music and give it to the marching band. Couple of months of practice, and by the 4th of July, you'll have yourself a humdinger of a retraction.
Stop. I just can't take this case anymore. Let's turn it over to the jury to figure out.
A fine idea, Your Honor, a fine idea. Why, I can remember when...
You be quiet. Gentlemen, since your testimony is finished, would you be so good as to give us a song before you go? Thank you so much. The jury will now deliberate, and I'm going home to rest. You be the judge.
Well, hello. I'm Robert Donnelly. I'm the Director of Regulatory Affairs at George Washington University, and I want to thank you all for being here. It's so great to be back here at Children's National doing another one of these theatrical productions, and I think we've had a very interesting opportunity today. This most recent case was based on something that happened at obviously one of our most prestigious academic institutions in this country, and certainly the oldest, Harvard. It's based on the case of Mark Hauser. He had, for 20 years, been an absolute leader in the field of animal cognition research, and he had become an outspoken advocate for the idea that animals possess many of the abilities that we think of as uniquely human. In that regard, his scientific work suggested morality had an evolutionary basis in animals, and he was really sort of promoting that. And I think somehow it may have gotten the better of him. He joined Harvard in 1992, just 32 years old, and he was almost immediately a recipient of a National Science Foundation Young Investigator Award. So his career was well set. He later won a Guggenheim Fellowship in 2005, but then circumstances arose and the Research Integrity Office at Harvard got involved in reviewing some of his experiments, and the results were unfortunate for him, certainly, and for the university, and also for the scientific community, because his research had been reported for such a long period of time, and ultimately there was an inherent unreliability associated with it. So in 2007, Harvard, the Office of Research Integrity, began an investigation. It lasted for 3 years, which is a very significant amount of time. Normally, a research misconduct case is supposed to be concluded in 180 days. So 3 years obviously indicated that there were a lot of issues and concerns to address. And then subsequently, the Office of Research Integrity within the Department of Health and Human Services got involved, and they took the case from there, and they spent an additional 2 years reviewing it. So we're going to go over some of the questions. These are for discussion, maybe not necessarily one absolute correct answer, but we'll go to see what you think. So questions for the jury. So how should the researchers have resolved the conflict over the scientific method used to code the observations? Answer A is to use Professor Hill's results because he's the most experienced observer. B, use an additional impartial observer, which was suggested in our case, to resolve the coding discrepancies among the original observers. Allow Professor Hill to repeat his observations and recode the data, or ask the Research Integrity Officer to solve the methodological dilemma. The jury may now vote on that. All the votes in? Aha. Well, we have a very astute jury here today. Let me ask, for the people who voted for D, we have someone who can be the spokesperson for that answer? It's also a very good answer, but the Research Integrity Officer is involved in oversight of research misconduct cases, really from a process perspective. Their job is to make sure that everything is done in a very fair and impartial way and that the university's policies and procedures are followed, and also federal laws and regulations when that becomes necessary. They are not the experts in how the science should be conducted, and they do not resolve methodological or other scientific issues at dispute. But they can be consulted if there's any reason at any time in any experiment to suspect that something is going on that's not well supported by the science and perhaps involves one of the 3 issues associated with research misconduct reviews, which are fabrication, falsification, and plagiarism. So D is not exactly correct, but using an additional impartial observer is a normal and accepted way to try and resolve disputes in coding, and sometimes coding is somewhat subjective because it's dependent on individual observation, and there could be good faith mistakes that are made. So that, I think, is the correct answer there. Dr. Hauser's experiments, he looked at the monkey's ability to distinguish these different sound patterns as was depicted in our case for infants. The researchers watched videotapes of the experiments and they coded how the monkeys reacted. They also did this in a blind way because they didn't know what the tones were. They were just observing the monkeys to see whenever they would turn and look at the source, the sound source. So they didn't have a way of sort of being prejudiced or biased in looking for when the monkeys would turn to that. And then we had two researchers who independently coded videotapes so that their findings could later be compared to eliminate errors. That was the methodology involved in the case. As I mentioned, the Office of Research Integrity got involved, and they concluded that Dr. Hauser was responsible for 6 counts of research misconduct. This was in a case that was published in 2012 by the Office of Research Integrity. They said the data concluded the monkeys could distinguish between different patterns of syllables and was published in Cognition back in 2002. Was fabricated. So here you have a research misconduct case that stretched from initial publication in 2002. The underlying experiments were done before that. Finally adjudicated in 2012 is involving research misconduct, a very long period of time during which other scientists around the country, around the world were looking at this data and using it to generate additional research and reviews based on information that ultimately was determined to be fabricated or falsified. And that's the danger. That's what the Office of Research Integrity is looking to do, is to make sure the scientific record is solid and an appropriate foundation for additional research to grow and be developed based on that. Dr. Hauser was involved in falsifying the coding of monkeys' responses to the patterns of consonants and vowels in these unpublished experiments. And he had determined that the results were significantly, statistically significant. But the colleagues coding the data found that there was virtually no significance at all. In fact, there was some indication that the monkeys weren't paying any attention to the source of the sound. The ORI findings were that the manuscript submitted in 2002 to Cognition falsely described the coding methodology. Dr. Hauser initially claimed that he did have 2 blind observers coding, but in fact, for at least one of the experiments, all the coding was done by Dr. Hauser alone. In a revised manuscript, Dr. Hauser reported fabricated values, and the proportion or number of animals reported in the manuscript as showing a favorable response was also found by the Office of Research Integrity to be false. So if you were Stills or Nash, first of all, would you have been working as a postdoc if you were Stills or Nash? Probably not. But anyway, in this case, if you were Stills or Nash, how would you have reported Dr. Hill's suspected research misconduct? A, I wouldn't have reported it. Reporting might create enemies and damage my career. Maybe talking to the head of the department, by talking directly to the research integrity officer, or by making an anonymous report through the institutional compliance hotline to avoid retaliation. Let's have the jury vote on that. Okay, are the votes in? So it looks like the predominant vote is to file an anonymous report. Could someone explain why that might be preferable to talking to someone about it, either department head or the research integrity officer? It is somewhat less involvement, isn't it? And these cases can be long and difficult, so it's understandable. And obviously institutions provide this as a mechanism to encourage any and all issues to find some way to be reviewed and evaluated, because the institution obviously has a very strong interest in ensuring that research misconduct is not, perpetrated within the institution. It's not only a problem in terms of the research record, but it greatly affects a lot of things. So this is a legitimate and appropriate choice, and it's absolutely fine. From the perspective of the Research Integrity Office, sometimes when you're dealing with an anonymous complainant, there are certain facts and points that are important in terms of pursuing the inquiry and ultimately investigation. And without an established complainant, sometimes it's more difficult to make the case, but certainly going through an anonymous reporting source is absolutely fine and completely acceptable. Sometimes talking to a head of a department can allow you to get some additional protection and understanding that there's some issue or dispute going on at a lower level within the department, and so that can also have some benefits. So any of these choices are probably good except for A. Here at Children's National, allegations of research misconduct have to be reported. It's policy, the same at the George Washington University. At Children's, the allegations should be reported to Dr. Mendel Tuckman, who is the Research Integrity Officer here. Anyone receiving an allegation of research misconduct can also promptly forward it. So if you're a department head and you get an allegation involves fabrication, falsification, or plagiarism, you want to get the Research Integrity Officer involved right away. There's a lot of processes that are required to protect confidentiality and also to protect the evidence, the evidence record. So having the Research Integrity Officer involved in the case as early as possible is always a good idea. There is also the possibility for our majority answer from the jury to report anonymously through the Children's National Toll-Free Compliance Hotline number, Telebear. So that's where you can report that. At George Washington University, the Research Integrity Officer is Sheila Garrity, and any allegations associated with research misconduct would be reported to Ms. Garrity, and those allegations will be handled with utmost confidentiality. That's our GW's compliance help and referral line, which can be used for anonymous reporting. So let's talk about publication. Should Professor Hill retract his publication? We have here a no, yes, and it depends, and only if he's found guilty. Let's vote for that. All right, I see our timer is a little short, so I'm going to jump to the answers. So the outcome of this case is that the paper that was published in 2002 was retracted in 2010, and there were other publications that were retracted or corrected. There were also some cases where, as a result of the investigation, some of the papers that were in the process of being published were corrected before they did get published. Dr. Hauser ended up resigning his tenured position at Harvard in July of 2011. This occurred after his colleagues voted to bar him from his teaching duties. They placed restrictions on his ability to conduct research for 3 years. Dr. Hauser no longer has a career in research academia, but he is doing some work with at-risk children and trying to get back in good stead in that regard. So I'd like to have Adriana come up and just have a final word, and thank you very much for your attention and your outstanding role as juries in this case.
So, the advocates of the jury system say that we need to keep with the jury system because in the majority of cases, the jury gets it right. And I have to say that was the case today. the majority of the answers, basically all the answers were very much in line of what the Research Integrity Officer, the Office of Research Integrity, and the court have decided in these cases. So this is a wonderful jury. Thank you all for coming today. At this point, I would like to invite the members of the cast and the moderators on the stage for our final bow.